In the early morning hours of November 13th, 2022, 4 University of Idaho students were stabbed to death inside their off-campus home. Ethan, Xana, Maddie, and Kaylee, all gone. The brutal crime shook the community and touched the nation, setting off an intense manhunt for a killer. Investigators from the Moscow Police Department joined forces with the Idaho State Police and the FBI, following every lead, every tip, and every piece of evidence. That investigation took them across the country to Pennsylvania and led them to this man, a grad student at a neighboring university. Today, he was back inside a courtroom in Moscow, trying desperately to have his indictment thrown out by the judge. Tonight, we have the latest from the courtroom, plus we take another look at the route investigators say the killer took, retracing his path and looking at surveillance video from that night. Does it show the killer's car, and does it lock in the timeline of this murder? This hour, we continue our investigation of the Idaho Student Murders. I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. It's the biggest story that we're covering. It is the biggest trial on our docket. And today, some news to get to, plus some videos to get to. But I want to start here, as we always do and always should with this story. It's about the 4 victims. An awesome group of friends. That's who they were. And, you know, any of you who are a bit older like I am, and you think back to those times, or you have children of that age, you understand what a magical time it is in your life. A time where you're beginning to become an adult, you're making good friends, and you're getting ready to forge your way and make your mark in the world. And that's exactly what they were doing. And unfortunately, we talk about them now. They're victims, all 4 of them, gone. Now, the suspect, the defendant, strange guy, but presumed innocent. That's the way our system works. No matter what you think about what the evidence may show, at this point, he's still presumed innocent, and when that trial starts, that's exactly what the jury will be told. The man you're looking at, he may look a little strange. The judge won't say that, I will. He's presumed innocent, and it's up to the prosecution to prove this case. And one thing you need to know about this defense, it's going to be a strong, vigorous defense for this accused mass killer. His team is smart, and they play for keeps. There are no slouches here. We've seen cases here through the years on Court TV where you've said, man, what's going on with that defense team? That's not the case here, okay? So you've got that presumption of innocence. You've got a really smart, really strong defense team. So if you're prosecuting this case, you need to bring your A game. Now, can they, will they? We'll see how it all plays out inside the courtroom. But I know, I'm a former prosecutor. You've got that burden. And don't discount it. It's beyond any and all reasonable doubt. And sometimes we've gone into cases that seem to have a mountain of evidence. Some of the most high-profile cases in the history of this network. One of them out in California involving a former football player. One down in Florida involving, I don't know what she was. She never had a job. But she used to have a child. And both of those juries, in cases where the public going in are like, hey, no. The jury takes their jobs seriously, and you've got to prove it to each one of them beyond a reasonable doubt. And it's really up to this prosecution team to do that. So everybody back in court today. There were some arguments today. I said the defense is strong and vigorous. They're fighting every legal issue, every factual issue along the way. Let's take a listen to what happened today in court, and then listen to the judge at the end as we get some more information about how this case is going to play out going forward.
Give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed.
Whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. The defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor.
What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone.
In my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. With that, I think we are ready to go to setting a trial. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. There are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. I'm realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything, to do it correctly, we don't want to do this twice. We don't want to do this 3 times, because no matter what happens, okay, if he's convicted, it's going to be appeal. That's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief. because you can't really go forward with your life without this hanging over your head. So, sorry. I want to do the right thing.
March 2025 is what they're targeting as a date here. That's the earliest this trial is going to happen. Our understanding, this thing could take 3-4+ months of testimony, everything else.